to this guidance on copyright, which is part 3 in our series about documenting coronavirus in Warwickshire. We will start by thinking about what copyright is and then move on to see how copyright may affect your archiving activities. Copyright, put simply, is the right to copy a particular work. Examples of copyright works are artwork, such as drawings and paintings, writing and other literary works, a play, sound recordings, photographs and film. Copyright in England is governed by the Copyright Designs and Patents Act 1988 as amended over the years. The Intellectual Property Office is the official government body responsible for intellectual property rights, including copyright, in the UK. Click on the link to visit their website, which contains lots of useful information about managing copyright. The owner of copyright in a particular record can control who may copy or otherwise exploit their work. Copyright is usually held by the creator or author of a record, for example, the painter, photographer or writer. Where a person creates a work in the course of their employment, the copyright will usually belong to their employer. You can see more about this on the IPO website. Copyright protection automatically exists when a work is created. You do not have to register the right for it to exist. Ownership of copyright can be transferred from one person or organisation to another. Copyright can be sold, gifted or left to someone in a will. Any assignment of copyright must be set out in writing and signed by the copyright owner. You can find out more about this on the IPO website. It is a good idea to ask copyright holders to transfer copyright to your organisation when a record is deposited with you. We will discuss this in further detail later. Copyright in records typically lasts 70 years after the death of the creator of the work. However, this is a complex area, and whether something is still in copyright depends on many factors. The National Archives have provided helpful flowcharts at the end of their copyright guidance to help you work out if a particular record is still in copyright. Where you are collecting records made recently in relation to coronavirus, it is likely everything you collect will be in copyright, and you will therefore need to consider this whenever dealing with your collections. When someone offers you a record for your archive, you will need to check if the record is in copyright. If it is, you will need to establish who the copyright holder is. Remember, this will be the person who created the record in most circumstances, and may not be the same person who deposits the record. Once you have traced the copyright holder, you can ask them whether they will transfer the copyright to your organisation. This will help you to be able to use your collections without having to keep contacting the copyright holders every time you want to make a copy. Don't forget, you will need them to sign an agreement to transfer the copyright, which will then need to be kept as proof of the assignment. If they won't transfer the copyright, ask what they are prepared for you to do with the record and whether they will grant you a license to make copies in certain ways, for example, for any non-commercial use. If they won't assign or license the copyright to you, make sure you emphasise the importance of providing their up-to-date contact details to you, so you can contact them if you need to ask permission to copy the record. If the copyright holder is unknown, you may need to consider treating the work as an orphan work. We will discuss this later. If a member of the public wants a copy of one of your records, you will need to consider whether you are the copyright holder. If you are, you can make a decision about whether to provide a copy. If you did not get copyright assigned to you when you accessioned the record, you will need to check what the copyright holder gave you permission to do with their work, or get their consent to provide a copy. There are also some exceptions to copyright that members of the public can take advantage of. Researchers are allowed to copy limited extracts from works for the purpose of non-commercial research or private study. The results of any research must sufficiently acknowledge the copyright holder. There are several exceptions that allow copyright works to be used for educational purposes and to improve the accessibility of your collections for disabled visitors. You can see a list of the copyright exceptions on the IPO website. The Copyright Designs and Patents Act includes an exception for archives, allowing them to supply a copy of unpublished works. An archivist, or someone working on behalf of an archivist, may make a single copy of an unpublished work, providing that the researcher gives them a written declaration. The declaration must include the researcher's name, confirmation they haven't already been supplied with a copy of the record, and a statement confirming the copy will only be used for non-commercial research or private study. You can find a template declaration form on the Libraries and Archives Copyright Alliance website. If you do not employ an archivist, you can seek guidance from the Intellectual Property Office or the National Archives on whether you can use this exception. Where the copyright holder of a work is unknown and cannot be traced, the work can be described as an orphan work. You may still be able to use orphan works despite being unable to get permission from the rights holder by obtaining an Orphan Works license from the Intellectual Property Office. You can find out more about this on their website. Here are some resources that you might find useful as you explore how copyright is going to affect your archive. I hope you found this presentation interesting. Thanks for listening.